Hi everyone, welcome back to Law School Gems with Bria. My name is Bria and I am a practicing in-house attorney for a publicly traded company working in their marketing and advertising legal group here in Dallas, Texas. I am so excited to be here with you guys today. Today we are going to be jumping into part 2 of legal writing, talking about citation and more research, etc. This topic came up because, again, when I was speaking to practitioners, a lot of them were running into issues with law students not knowing how to write, either in their internships or externships, or even after they've graduated law school, right? And legal writing is one of the most key and essential foundational elements you'll need in your legal career, which is why it's so important, but it's something that you're always having to sharpen and get better at and work through. And it's also something that you can constantly improve upon. So if you are here, no matter where you are at in your law school journey or beyond, you can really take away and benefit from some of the tips and the best practices I'm about to drop right now about citation and research. But before we dive in, I just want to thank you again for being here. You could have been anywhere else in the world, but you're showing up and you're doing the work because you want to get this great knowledge. You want to get these gems. And I appreciate you for that. I appreciate you for coming as yourself, being present, getting this great information. I hope it's supplemental to what you're doing in your law school journey or what you're about to do in your law school journey if you are considering going to law school, or if you are an admitted first semester law student about to enter your first semester of law school, right? So congratulations for showing up and being here for yourself. You should applaud yourself for that. Breathe in with me and breathe out. And without further ado, let's jump right in.
We are born to win. Come and learn the basics with Law School Gems.
Citation, right? It's critical to your legal writing because you cannot plagiarize your work in law school, honey. The information put in your legal writing that did not come from you or that is not an original thought must be properly cited to give the originator proper credit. You will typically use legal citation in your rule explanation, if applicable, and analysis sections of your legal writing. The way in which to properly cite a case or other research material can be found in your legal citation book as prescribed in the course syllabus for your legal writing course. Some professors may require that you purchase the Blue Book, and I will drop a link of where you can purchase that book in the section below this video. Some professors may require Allwood, a guide to legal citation. I will also drop that link below. Or maybe they require both. Purchase the latest editions of either of these books and be sure to look that you are properly citing cases and other research materials according to the latest citing guidelines for those books. Otherwise, you may risk a major deduction of points that go toward your overall writing assignment grade. My preferred recommendation, if you have a choice on which legal citation book to purchase, is the Allwood Guide to Legal Citation. I find it more digestible, easily accessible, and better organized. That said, however, the overwhelming preference for legal citation books in most law schools and beyond is the Blue Book. So you'll see this when you enter the workforce, and the only legal citation book purchase is the Blue Book. So that may be all that's available to you. So if you want to go with the legal citation book that is most preferred, only because it's been around longer and the legal landscape is slow to change, to be honest with you, then I would totally understand that, and by all means adopt and use the Blue Book. If you're a Texas law student only, this is specific information for you. If you are enrolled in a Texas law school, please purchase the Texas Rules of Form, the Green Book, in addition to either the Blue Book or Allwood Guide to Legal Citation. Texas has state-specific citation methods for its case law, specifically for appellate level cases and beyond. The Green Book will help you cite Texas state-specific cases. Please find the following link to the Green Book. I will link that below. And the Blue Book and or Allwood Legal Guide to Citation or Guide to Legal Citation will help you cite federal, national cases and other secondary materials. Example of a properly cited federal case in basic form looks similar to this. So take, for instance, Bennett versus City of Grand Prairie, 883 Federal Second Reporter 400, 407, and then in the parenthetical, 5th Circuit, 1989. In this example, the first part of the citation is the case name, which consists of the last name of the plaintiff and the defendant's entire name because it's an entity. The case name is always italicized or underlined, as you can see on the screen. Choose either italics or underlining and be consistent with that usage throughout your response to your legal writing assignment as you cite other case names. Your professor may have a preference of which emphasizer to use, but if not, then go with your preference. Either manner is correct legal citation. The second part, for example, which is the 883, is the volume number of the reporter that published the case. The third part, which is the F.2 lowercase d, is the volume reporter. The fourth part is that 400 number, and that's the page number within that published volume in which the case begins. So that case begins on page 400 within that volume of that reporter. The fifth part, that 407 number, is the pinpoint citation for where exactly within that case you located the information you were citing. So that's the precise page number. And the sixth part is the name of the federal appellate court where this case made its way to. It's always important when citing a case that you are citing the latest version of that case. The case with the most finality. In other words, which court resolved any lingering issues in the case the last. That's the version of the case you want to cite. There is an exception to this. Cases most always start at the trial court level, where the issues are tried before a judge or jury and then decided before arriving at an appellate court. Some cases never make it past the trial court level, and the trial court is the final decision maker on all issues. Other cases that do make it to the appellate level may not address the issues relevant to your legal writing assignment. Always be sure to cite the latest version of the case from the last deciding court that addressed your relevant issue. Thus, even if a case you were citing made its way to the appellate level, but that court didn't address your relevant issue, then the latest version of that case that you would cite for your purposes would be the trial court's opinion as to your issue, because that was the last court with finality as to your issue. The seventh part of the Bennett case example that we gave, that's here on the screen, is the year in which this case was decided, and that year was 1989. This case citation example does not include a case parenthetical, which would give further appellate history if necessary, or a brief explanation of the case or its holding, right? So pay attention to the details in the case citation example. Notice the comma and parenthetical placements and the spacing, because all of those elements form the proper citation for a case. Your professor will judge your citation based on these elements as well. So if you miss any of those elements, then your case is not properly cited and your professor will deduct points. With respect to rules, speaking of elements, many law students that I have spoken with have found it hard to understand the composition of a rule from a case. Rules consist of one or more elements, Rules consist of one or more elements, all of which must be satisfied. Rules are taken from case law, which are used to support your response to a fact pattern. The elements of a rule are satisfied by applying each element to the facts of your case. If even one element is not satisfied by the facts of your case, then the entire rule fails and it's unsatisfied. An example of this is the rule of negligence, which consists of 4 elements. Negligence consists of duty, breach, causation, and damages. Whether someone is negligent is an issue solved by applying each one of those elements above to the facts of your fact pattern, starting with the first element. Always start your analysis with the first element of a rule, because it doesn't matter if the other elements are satisfied if the first element is not. If the first element is not satisfied by the facts of your fact pattern, then the rest of the rule fails. If the first element is satisfied, then you move on to analyzing your facts using the remaining elements. If all the elements of the rules are met, then the conclusion to the issue would be yes, someone is negligent if we were using negligence as the rule. If not, then your conclusion to the issue would be no, someone is not negligent if we were using the rule of negligence as the rule. Within the rule paragraph of a case, a court will sometimes explain a rule or determine whether an element of a rule is satisfied by giving you a factor test. The factors do not have to be satisfied in the way that elements of a rule must be satisfied. Factors are used as a guide. Factors should be added to your rule explanation in addressing a fact pattern. Factors should be included in your analysis in a similar manner that the case law includes the factors in its analysis to determine if an element of a rule exists. It's not a requirement. Let me repeat that. A factor is not a requirement of a rule. It's not a requirement for every factor to be addressed within your analysis either. However, you should follow the analysis of the court as a guide on how to apply the factors to your analysis, which factors to include, which are more important than others, etc. And you'll look for that guidance from the case law that you were researching. Whether any factors should be mentioned in your analysis is ultimately going to rest on the facts of your fact pattern or writing assignment and whether those facts lend themselves to those factors. Now that we've talked a little bit about legal citation and research, let's talk about sentence structure now. Apples to apples. That is an example that I was taught in law school by my writing resource center professionals, right? That when writing, your sentences should be congruent, especially when combining a dependent and independent clause or making a list within a sentence. In doing so, the sentence reads clearer. So for example, let's discuss an example of a sentence that's not apples to apples, right? I'm going to give you this example on the screen. Research the appropriate attire for the event you are attending and ensure you are dressing accordingly. A proper apples to apples sentence structure for this example I just gave would look instead like this. Research the appropriate attire for the event you are attending and dress accordingly. So what I did there by reshaping or remolding or refashioning that sentence to make it better in the example that I just gave is made sure that the verbs were congruent. I made sure that the two independent clauses in that sentence were also congruent, and I reduced wordiness. And so it made the sentence more sharp, more clear, more concise, and that makes for better writing. And ultimately, that is what your professor is looking for, because that is how we speak in plain English. Speaking of plain English, be sure to write in plain English, but understand that how we speak colloquially is not necessarily plain English. Sometimes how we speak consists of slang or other colloquialisms that are not appropriate for how we write as lawyers. There is a difference between writing in plain English and writing how you speak. So learn that difference, and if you are unsure, always be sure to ask the question. And guys, that's all that I have for you for this video of Law School Gems, Legal Writing Part 2. If I forgot any information or you would like me to supplement anything, please feel free to drop it in the comments below and I will be sure to respond or update with a supplemental video. Thank you for watching again. You could have been anywhere in the world, but you're here with me and I really appreciate your time. Please like this video. Be sure to share it with a friend if you think they would benefit, specifically someone who is in their first semester of law school, about to venture into their first semester of law school, or who is considering law school, and even people who may be further along in their law school journey and just need some best practices when it comes to improving their legal writing. They'll be sure to benefit from this video as well. Always subscribe to the channel so you can get notifications for when I drop more Law School Gem videos. And as always, thank you for watching until the very end. It really helps me out so I can continue to grow this channel, which is all I want to do to help reach more audiences and more law students or soon to be law students like you. I will see you guys again next week where we will be discussing more legal gems that I will drop. And as always, have a great, safe rest of your week. Take care, and I will see you guys next time. Bye, guys.